One early evening in 1953, McFeeters was walking home when he was struck by a car and killed instantly. The driver fled the scene and there were no other witnesses. The only evidence was physical evidence of tyre markings, paint residue, and the body of the deceased. His widow brought a claim against the nominal defendant, arguing the driver had been negligent. In negligence, the plaintiff bears the burden of proving their claim. Mrs. McFeeters had to satisfy a jury that the driver of the vehicle had been negligent by driving too quickly, or by failing to keep a proper lookout, or both. This was difficult because, like many circumstantial cases, the facts gave rise to a number of possible sets of circumstances which could not be excluded. For instance, Mr. McFeeters might have suddenly run in front of the car. The car might have suffered an unexpected mechanical fault. McFeeters, who was wearing dark clothing, might have been difficult to see. The jury found that the driver had been negligent, but that Mr. McFeeters had contributed equally to his death by contributory negligence. The nominal defendant appealed, arguing that there was no safe basis upon which the jury could have found that the driver had been negligent. The court found that the task for the jury was to work out, on the basis of common experience, whether it was more likely than not that the driver had been negligent. A majority, with 2 dissenting judges, found that it was open. The majority judgment said, "We should think that inferences sufficiently appear that make it at least more probable than not that the unidentified vehicle was being driven in a negligent manner, and that this was the cause of the accident. Castle Bar Road is a street with lights, the night was fine and clear, and there were no trees or other objects to obstruct the driver's vision. The headlights alone should have provided the driver with quite satisfactory vision. Yet the vehicle not only struck the deceased, but pushed or carried him for 42 feet and then ran over him before it stopped. Nor can the fact that the driver took refuge in flight be overlooked." While civil juries are now rare, from this case we learn that courts are inclined to be generous when making inferences in favour of an injured or deceased person in negligence matters.